the Companies Act, Section 17, change of name. Subsection 1. A company may, by special resolution and with the approval of the registrar, signified in writing, change its name. Alright, let's look at this phrase here. Special resolution. I find some information on a website called rocketlawyer.com. It says here, what is an ordinary resolution? First of all, the ordinary resolution. It said the majority of resolution used for routine changes which simply need a majority, which is more than 50% of shareholders or directors, to agree or disagree on a decision are known as ordinary resolution. This type of resolution can be passed with a show of hands at a meeting. Such decisions which require ordinary resolutions are appointment or removal of company directors and secretaries, or authorizing directors' loans, or amending the powers of directors of changing their employment contracts. Alright, what we want to look at now is special resolution. Special resolutions, also known as extraordinary resolutions, are needed for more important decisions or those decisions affecting the constitution of a company. These require at least 75% of the shareholders or directors to agree, and in some situations as much as 95%. Unlike ordinary resolutions, votes are determined by the number of shares given by each shareholder, as opposed to the number of shareholders. Or types of resolutions include changing the name of a company, making changes to the article of association, same thing as the article of incorporation, or changing a private company to a public company. Alright. Now, just before we come off this resolution business, I see written resolution. Although general meetings are shareholders or for shareholders or board member meetings for directors are normally required to pass resolutions, some decisions can be passed in writing without the need for a meeting. If enough shareholders or directors have agreed with a decision, a majority for ordinary resolution and at least 75% for a special resolution, this can be confirmed in a written resolution. Okay, so here we continue now. So you need a special resolution for the company to change its name. Subsection 2. Where a license granted pursuant to Section 16 to a body the name of which contains the words Chamber of Commerce is revoked, the body shall, within a period of 6 weeks from the date of the revocation of such longer period as the register may think fit to allow, change its name to a name which does not contain these words. Alright? So, you, the directors, can change the name of a company, or you can be forced to change it by the registrar or the courts. Right. Subsection 3. If such a body makes default in complying with the requirements of subsection 2, it shall be liable to a fine not exceeding $2,000 for every day during which the default continues. Right. Subsection 4. Where a company or a body changes its name under this section, the registrar shall enter the new name on the register in place of the former name, and shall issue a certificate of incorporation altered to meet the circumstances of the case. Subsection 5. The change of name shall not affect any rights or obligations of the company or body, or render defective any legal proceedings by or against it, and any legal proceedings that might have been continued or commenced against it by its former name may be continued or commenced against it by its new name. So just because the name changed does not mean that those people who sue you, who sue the company, have anything to worry about. It does not affect the lawsuit. If the company sue another company or somebody, that does not affect the lawsuit either. Whatever money you owe, you still owe. Right? Alright. Subsection 6. Where a company or a body changes its name under this section, it shall cause notice of the change of name to be published in the Gazette and in a daily newspaper printed and circulated within the island within 30 days after the date on which the registrar approved the change. And if the fault is made in complying with this subsection, the company or body and every director, manager, secretary, or other officer of the company or body who knowingly and willingly authorizes or permits the default shall be liable to a fine not exceeding $50,000. So, if a director did not know or did not allow this breach to occur, they wouldn't be fined. But once the director knew about the breach or facilitated or committed the breach, then they will be fined. So once the name of your company changes, you must advertise that change of name in a daily newspaper. And that must be done within 30 days after the date on which the registrar approves the change of name. Daily newspaper nowadays means the Gleaner or the Observer, right? I don't think the Star would qualify as an evening newspaper. So either the Gleaner or the Observer. Alright. Reservation of name. Section 18. Reservation of name. The registrar may, upon request and upon payment of the prescribed fee, reserve a name, reserve for 90 days a name for an intended company or for a company about to change its name. If you're going to form a company, you come up with a very good name, but you're worried that maybe somebody register that name tomorrow morning or next week and you're not ready to register it yet. You can reserve that company name for 90 days. Next is general provisions with respect to articles. So we'll look at that in the next video. But so far what we covered was change of names of a company. It requires a special resolution, or you, in some cases, you have to change the name because the registrar or the court forces you to change the name of the company.